questions about the fact, that was really where I was going about you weren't a poor student, that she had her own independent existence. I would have liked to gotten her to say, but I didn't have any confidence I could, that perhaps she had bank accounts of her own. Just because you say Boston, for the tribunal to therefore conclude that must be Bottoni in the light of the record as a whole gets a bit problematic. And, you know, just as she says, oh, well, this must have been Bottoni telling lies, it seems to me that's equally plausible, that she could have been simply, you know, needed an excuse to tell the bagman, or the recipient of the bribe, I should say, that she needs more time. So she says whatever she says. But it seemed to me that since we would likely already be in a world of denial, I have no idea, gee, I can't explain that was an acceptable risk to take.
George, you have any comments?
Sure.
My colleagues.
I mean, we should say just one further point, that the exhibit is in the record, I take it, right? So for both sides to kind of whistle past the graveyard as if it doesn't exist, at least I hope to give a plausible explanation as to how, you know, how basically she was a lone ranger and only went to Boston after she had already put in motion what led to the demise of this.
Okay. I think it's interesting, given our earlier discussion about styles, that both of you asked exclusively leading questions, maybe one or two open-ended questions sprinkled in, but they were kind of safe ones. And now, as an American lawyer, I wouldn't call either of you in any way belligerent. You were very respectful, except I thought, and you got a snicker out of the witness when you read, Tim, when you read the note, the reunion note. It was kind of dramatic, but you wanted to emphasize certain points, and so that probably came across. What I'm interested in, and I'd like your comments on it perhaps, if we have time, is there were two specific points that you went about a little bit differently. You were making more or less the same point, but you did a little differently. One of them is the obvious contradiction between paragraphs 10 and 17 about the contract, where she says in paragraph 10, the contract clearly allowed sales beyond the power plant. In paragraph 17, she says she told Bottoni that it wasn't clear. Tim, you, in the style that you did it, you sort of had this slow drip, drip, drip of things you wanted to establish up front before you got into the meat of your examination. And then you got to paragraph 17, and you read those statements, and then you went back to paragraph 10, and you got a little tangled up because she talked about how she had to talk about the risk with him, and you said, well, shouldn't you fix the risk up front? But, you know, she said in paragraph 10, the contract said this. So I think you still made your point, but it was, there was quite a separation between the two. Whereas Steve, you juxtaposed them right next to each other. You started with 17, where they're telling Bottoni that, it wasn't clear, and then you went back to 10 and said, well, wait a minute, you said in paragraph 10, paragraph 4 of the agreement clearly says this. I don't know if that's worth commenting on, but I noted that was a little different in the way you approached it, and whether you thought about it that way or whether that, just happened in the way you presented the questions.
In my case, there was no great magic about it. I always am kind of reverse teleological. In other words, I start at the back end and try to figure out what I want to establish and then build my cross from there back. One of my themes, of course, was that this was a person who trusted this lawyer from the get-go and up until the time that I would say even after the bribe took place. That's certainly what I would argue in closing. So for me, there was kind of a second theme in that, which is that, I wanted really more than anything else to establish that he was relying on her for Juristanian legal advice, just as he was relying on her to deal with government officials. And to me, I just wanted to pick up the obvious inconsistency, but I think it's one of those points that is worth making, but it doesn't seem to me that alone would cause a tribunal to throw out the credibility of the witness. So it was not a major point for me.
See, I think it's really cool that we've got two different approaches. my assumption with my case narrative is, look, she was in 50-50. She had joint control. It's utterly implausible. We don't have the board minutes. In real life, we'd have the board papers and documents that would destroy any denial about these basic business facts. I mean, anyone operating a mine for any length of time is going to have all of the reports of what's in situ going forward, and if you have finance, it's going to be there as well. I mean, any financier is going to demand reserves reports on a regular basis. So in real life, the record would be really toxic for her denials. I live with a world where we don't have that for this cross. But my narrative was pretty clear contract. She admits it's clear. It must have been in the real world that they knew that they'd be selling the surplus coal. The steam coal would go to the power plant to the extent necessary. The rest would go to the outside world. They'd make the real money. And that in October 2012, and she did admit this, the only thing that changed, the contract wasn't amended. The only thing that changed was the politics. And the answer to her last question was, the only reason I went to the Council on Foreign Trade was to get a politically convenient document. I didn't really think it was necessary. So if I'm pursuing that theme, and I like Steve's theme of the reverse. I mean, I took a slightly different interpretation of the meeting, and in real life you would have Horace tell you when the meeting took place, so that would be resolved. I took the view the meeting did occur in October 2012, that what she was meaning to say and what she would say was, yeah, I say in my witness statement the government was controlled by the opposition. What I really meant to say is the government was still a Direcco party, but it was enthralled to the opposition because of the political climate. So that was an assumed part of my narrative. And I was just panicking politically. And my closing would be, much has been said about the texts. They don't look pretty, but she was obviously panicking, and she's admitted it was not a necessary consent to give. What we do know is what the contract said and what she admits the contract said, which means that our export sales were never a breach of the contract, therefore she can't come at us. And so my narrative is, again, it's like I was making the assumption that we're fundamentally a defendant in this case.
Yeah, that's great. You both had different approaches and they were both effective, so yeah. It's just interesting to kind of tease that out. The other one I noticed was that Tim, again, in I'm calling the drip, drip, drip of, establishing all the basic facts before you got into kind of going into her witness statement. You established that and you both talked about this, the rotating CEOs, and you drew out that that Daisy Chapman was at the site regularly, and in fact, ultimately, which was really strong testimony, is that she saw the trains going from the site taking coal out to the port in Laurania, and that, obviously some of it was being exported, so she had to know that. And it seemed to me what you were trying to do is establish that, of course, the witness, who Daisy was reporting to, knew that, so her denials that she ever knew that this was going on are not credible. If I can just tee up the contrast, and then you each can comment on it, if it is in fact a contrast. Steve, your approach was, you said, you in effect tried to make Daisy someone who was concealing things. You said, well, you said, Ms. Montero, you complain about Mr. Bettany being clever and hiding things from you, but in light of the fact, and this wasn't your exact question, you asked it much better, in light of the fact that Daisy was the CEO of the company at the time, then she must have been very clever at keeping things from you too, which is a different approach, and I'm sort of interested in the contrast there, because Tim was trying to establish that the witness must have known because Daisy knew and must have reported it to her, where you were in effect impeaching their CEO. Or maybe you were trying to do the same thing in a different way. I don't know.
Well, I have to be candid. I wasn't aware there was a Maybe I missed
Well,
it.
okay,
I
no,
don't know
it-
where
it-
Daisy was, she just came up with that.
It just, the name, no, the,
Did I miss it, or is this?
no, but
No,
forget Daisy Chap, the name came up, but the fact that Montero appointed the CEO from 2011 to 2012 was in her witness statement.
The key
So,
is that she saw the cold winter.
right,
Yeah.
right.
That is in the facts, and when I read it first, I thought it would be a really good fact, and then I thought, well, no, she's going to say, well, the reason they built the road to the port is because they needed to import the plant and equipment, and I knew that was the only purpose, so that's when we tried to create a visual of the trucks going. It's not that fact alone is not necessarily dispositive of her knowledge, because the road could just be for imports.
You
Yeah.
were trying to establish that Daisy must have reported
Yeah, because
those facts to the witness.
the Harvard thing, which, let's be frank, it's easy to over-interpret the puff pieces that people do. You know, be careful of what you say on your website. But it did make her sound like a real control freak. Right.
And she's clearly a self-focused.
Yeah. Yeah. But I was impressed that she refrained from using the line she uses in the witness statement, that she's never been to this place because the weather is bad. I think that would have been, I was actually hoping that she would repeat that, because that was a particularly unconvincing part of her statement. But
When she made her statement in her alumni note, she talked about coal sales. And would it have been worthwhile to somehow lay a foundation there and say what was the relationship between the coal mine and the transfers to the power company? Wasn't that actually sale of power? And therefore, the coal sales must have been something you're bragging about to
Well, I did try and get in and out of that,
Asian borrowers.
but I was obviously too obtuse, I guess. I think I did quote that language and then point out that it's part of the strategic function that she says that she actually supervised and controlled. But, maybe it should have been developed.
And couldn't the witness have said, oh, you always exaggerate in alumni things because I want to impress my colleagues,
Which is why she was asked, it was pointed out to her that, she wasn't trying to win a case. That's the flip side of that, right?
Yeah.
But,
she's trying to look important and successful, which is usually what alumni try to do.
and the fact that she's prepared to overstate her case to do that is a valuable fact. to
Very
put before
valuable.
the tribunal.
Very valuable. There is both of you went into in paragraph 16, that Horace further said that the proceeds of the sale were only temporary in bank accounts outside the country, and that they, or a portion of them, would be brought back into the country following negotiations with the government. Ben, if you were doing redirect, would you have brought that out, since the door seemed to have been open on that paragraph?
Hadn't thought about it, might have.
Would that have been a good thing? Certainly would have hurt Framingham, because if you read through this, you think what her real problem is that she didn't get a share of what Horace was taking out of this place.
Exactly right, and that's our narrative of the case is whatever these sales went, our claim is she didn't get her share of it, and that's breach of the joint venture agreement. That's claimant's case, claimant wins on that. I mean, that's the key. Now, Tim, I think you looked at it a little differently, but I think, that's our theme here. If these sales took place and she didn't get her share of it, she's due something.
But to me, and this is a defense lawyer speaking, that's small beer compared to her massive claim for all the lost profits she would have got if it hadn't been terminated. And in real life, the defendant or the respondent in this situation would have offered some sort of accounting for that fair share. So for me, I don't know about you, I didn't see anything that was exculpatory for Horace in her statement on that point, and no amount of cross-examination of her will substitute for our client at the appropriate time making a proper presentation of its case and his explanation for where that money was going. There's no way you can ask her, isn't it true that you were going to get the money eventually? She'll just make another speech and say, oh no,
You bet, you bet. Sure, sure.
I think all you can point out, and I'm still kind of struggling with this, I don't know whether I've missed a fact or something, is the fact that it was the joint venture that was making the sales.
That's right.
And that happened to have been her CEO at the joint venture at the time. And I frankly was not prepared to take it any further because I couldn't really tell from the facts we were given what it would mean. And I just, I don't see any reason to let her make stuff up. She's very creative at doing it.
What about the fact that she was living in a elegant palazzo with her own gondola, one of the few in Venice, and that the palazzo was not owned by her, owned by an Andorran company, but she was living in it. Is there something to be made of that? Is this affect her credibility, or does it affect
only if we
the fact
can
that she
use-
was stealing money in some fashion and taking it out of her home country illegally?
There are lots of facts in the briefing note. And I was prepared again for questions of foundation and so forth. It was not clear to me whether I was going, and I thought about asking her if she had before her the parties' agreed statement of facts, because it seems to me that that's what these facts are. But if there's something less than that, I didn't want to be the one who found out. So, I mean, the gondola and all that stuff, if we could have crossed her on your statement of facts, I agree, but it wasn't clear to me that we could cross her. I did one or two just because I had to have those facts.
First note, I wondered why all the men in her life were called Guido.
Only two.
Also, with that kind of the Andorra thing, in real life, before you go after a fact like that, you have to do a very, very firm house check yourself, because the idea that she's involved in asset stripping or tax evasion by using some sort of company, we don't know for sure. For all we know, the Andorran company is totally above board. But for all she knows, she's going to give another speech about all of the sins of framing him. And so why give her that platform?
Well, Sophie, you didn't take too much advantage to inject anything consistent with your position, but what you kind of said yes, and how did you feel that they were
Well,
they were getting to pay dirt and cross-examining you?
I was under strict instructions not to be overly creative. I would have loved to. She's a great character, but I wanted to be more. I mean, not ham it up too much, because obviously in real life one wouldn't, right? You want to be quite reserved, and you would have been under instructions to be quite reserved. I expected slaughter from both, and I got a very civilized, very effective cross-examination, which I think is obviously to their credit. But I can tell anybody in the audience that this is a very uncomfortable chair to be in on any view at all, and this is something that I used to dole out to witnesses, and now I know what it's like.
Hey, let me make a comment really for the benefit of some of the audience members. Particularly early on, I was making some sidebar comments, I was making some objections. That's not really what counsel would be doing in international arbitration, and the formidable chair slapped me down pretty good, but it was just for entertainment. That is really, do not do that. If you're counsel in arbitration, don't do that.
But you say that, I mean, I've had it happen quite a lot, and I've also had counsel getting up and objecting, and I've bitten my tongue off saying we're not, tried to sort of calm it down without saying, well, actually, we're not a jury.
That is exactly right.
And it does happen that with, I'm afraid, mostly with American counsel.
Yes, yes. Don't do that. Don't do what I did. That was theatrics. We were just trying to juice it up for you after lunch, but don't do that. And she was right to, especially on the business of counseling a witness, that was a little bit out of line too. So,
Yeah.
but that was for fun. That was for fun.
David Haig, you were taking notes and thinking about it. Have you got any thoughts?
Well, on the complementary side of it, I thought that both counsel were very effective in their different ways. I noted the same thing that the chair of the tribunal had noticed. I had wondered when Tim Nelson was cross-examining why he left the Bob Kavanaugh texts alone. It seemed like a very big invitation to discredit the witness. But I can see the tactic that he had in mind when he explained it. I think there was wisdom in what he was doing. Restraint in cross-examination is sometimes a very difficult self-discipline, especially if you've got inviting targets. Keeping focused, and I think both cross-examiners in their individual ways did that. I suspect that part of Sophie's discomfort may have been because she realized they're both very well-informed cross-examiners. They've read her witness statement thoroughly, and that if she gets frisky at all on her answers, she's going to get nailed by them. They both know very much what they're asking her, and it would be unwise to get very far from the text. Not that she was tempted to do that, but she would be aware of that. That would add to her discomfort as a witness.
Just to go back to the beginning here, I winced a little, Tim, when you started off by taking a pot shot at the major in South American studies. You don't know who on the tribunal here has a kid who's majored in South American studies or something similar.
No, it was Southern Hemisphere studies.
Southern Hemisphere.
Of which I don't think there is such a discipline. At least I never thought so.
On a point of privilege, I have studied in the Southern Hemisphere, so I felt I was...
Hilary, you have some comments?
Well, I mean, I think most of the comments have actually been made. I mean, I find it interesting to see the different styles, as somebody said, both very effective. One sort of building up, one perhaps taking the question and knocking it down earlier, and both styles are effective in different situations. I think one of the unusual things here is it's all the materials concertinaed. In real life, you'll have to go through a lot of other material before you actually get to the points. And that's one of the skills, is you've done the selection effectively here for the cross-examiners. One of the skills will be not just looking at this pile, but looking at volumes and volumes of documents and extracting these bon mots in order to put to the witness. And that's a skill that you haven't, I mean, you've had to do it to a limited extent, but you haven't had to do it as one would in real life. But I don't think really there are many points really to add. As I said, I thought they were both very effective in different ways. And I think my colleagues have really made the points.
Yeah, I thought tremendous jobs from both, and it was a good example of different things that Ben was saying in his outline at the start here. You can do what Tim did, which is to set up some things you're going to argue later, rather than to try to blow them all up with the witness while she's on the stand. Or you can go for a really strong finish and try to make an impression on the arbitrator's minds right where you're sitting there. Either one's a viable way to do this. It also demonstrated different approaches to a witness statement. You don't have to be tied to it. Tim showed you can develop your argument and just refer to just little bits of it, or Steve had command of all of it and had right at his fingertips this paragraph, that paragraph, that paragraph. So you end up feeling, all right, this is really more tied to the witness statement. Either one works.
Just to add to that, I think one thing that one does see, and again, it's different styles, a lot of counsel will just go through the witness statement, paragraph by paragraph by paragraph. Other counsel will do it on an issue basis. Other counsel will really not look much at the witness statement, but take the witness to the issues, to the documents, and then if there's an inconsistency, go back to the witness statements. I mean, there are many ways to cut the cloth, and it very much depends, again, on the individual, on the style. I think sometimes a slavish adherence to a witness statement, particularly when everybody knows they're drafted by by lawyers, can sometimes not be the most effective way, but it very much, again, depends upon the case. And also, the other, I think, distinction is when you've got a short witness, you can deal with it very differently from when you've got a long witness. A short witness might just be easier to get through it quickly by going to the 2 relevant paragraphs. They've got 3 pages. If you've got a witness statement of 60 pages, you've got to do it very differently.
Does anyone else here in the room have some thoughts or comments? Yes. We'll bring up the microphone up to you.
Thank you very much. My name is Gordon McAllister. I'm from Crowell and Mooring in London. From the cheap seats here at the back, it was difficult for us to see, but I wonder, as a mechanical question, if you could tell us what you had in front of you while you were doing that. It looked, Tim especially, you had a kind of gentle disdain as you were flipping through the witness statement, which I just thought was supremely effective. And I'd be interested to see if you had more than that for your hours cross. It was very impressive.
We didn't have live note, and once or twice I could have done with it. So that was why I was just looking, because I'd missed the odd word. I think in real life, you'd probably just be looking up at the screen to just check the question. You might look at the witness statement, but what we have is basically, I think, what you have, which is the narrative and the witness statement and a few exhibits in this situation.
I think you're asking for the backstage information, the making of. First of all, I need to remind you of Charles Lawton when he's cross-examining Marlene Dietrich using the supposedly incriminating documents. And at the end of it, he says, "This is an order for a rather fetching pair of Bermuda shorts. This is the document," you know. So never assume that what you have in front of you is, this is an outline. I do this for every cross. And in the outline, I walk through the expected questions and then have, I can show you, I mean, underneath I have the matching parts of the witness statement. So I ask a question that will match the witness statement. And I do it much as you would do with a deposition in the United States. I treat, so you only go to the witness statement if they contradict something. This is at least my basic method. So every question where I said yes, you know, this is true, isn't it, was either I had a reference underneath to the assumed facts or to the witness statement. To her great credit, she didn't say, apart from on paragraph 10, that she didn't say anything that was at odds with so you were very well schooled in your statement and the facts. At the end of it, you know, and you just walk through the questions. So I have 25 pages, but a lot of it is like a key for me as to what she's going to say based on her witness statement. So I know that it didn't look as if I was using the witness statement, but it's all baked in. This is, you know, it's in the States, this is called an outline. In real life in cross, you can often tell how an American lawyer at least is going because you can see how far they've got in their outline.
Do you have arrows that I sometimes see with American, well, not only American lawyers, but arrows going this way? I've seen it that way, depending on all the others. I don't know how people follow that.
I didn't do the right, that's like a power, that's sort of a decision tree?
No, I've seen, I don't do it myself, but I have seen cross-examination of American lawyers with a sort of tree with arrows going, depending on if he says yes, if he says half yes, if he said no. I mean, I would do that in ordinary manuscript, but there's a sort of graph some people do.
So what I do, everybody's got their own different method. I'll let Steve talk about his. In a long cross, I would have this